Court will call State of Wisconsin versus Darrell E. Brooks, case number 21 CF 1848. May I have the appearances, please?
Yes, good morning, Judge Sue Apple, Leslie Basie, and Zach Witchow appearing for the State of Wisconsin.
Good morning, sir. Please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in these charging instruments, and I do not consent to or agree to being called their name, Your Honor.
All right, the record should reflect that the individual known to this court as Darrell Brooks is appearing in person in custody. He is also in civilian or street clothing, in a suit and tie, also wearing a mask. I have a question, sir, because you had indicated there was this United States v. Lopez. I had looked up a case. I don't know if it's the one that you were referring to. I asked you if it was from 1995. You thought it was. Have you been able to look through your documents to tell me which United States versus Lopez you were referring?
I have not, but I also cited Hagens versus Levine as well, 415 U.S. 533, or I think you may have corrected
I was
that.
able to find Hagens versus Levine and Malo versus United States. I also found a case that is captioned United States versus Lopez. It had to do with in part with the
jurisdiction.
No, it had to do with a provision in the federal statutes regarding the gun safe free zone and whether that was constitutional or not.
My understanding of that particular case was dealing with the specifics of subject matter and personal jurisdiction, which is why it was brought up for the record, which is something that I have been doing adamantly, is asking for the court to provide verified proof of jurisdiction, which I have not been provided with as of yet.
Court's not required to do that, sir. I understand what your objection is. It's been noted for the record multiple times, and the previous rulings of the court stand. I see no reason to revisit those issues, even if I were to take your reference to these cases as a request to reconsider based on a new legal argument. The cases that I reviewed don't support that. I do want to give the state an opportunity to at least make a record as to their position, and then I'll give you the last word if you want to make a legal argument to the contrary.
I do.
I did review the U.S. versus Lopez, the Lopez case that you cited at 514 U.S. 549. As the court already indicated, it deals with the Gun-Free School Zone Act, which is a federal offense. The court found that that Congress exceeded its authority under the Commerce Clause. I don't find any analogy between that case and this case. With regard to Malo versus United States, this was a case involving an accident that the plaintiff had with an employee of the U.S. Postal Service who was driving a U.S. postal truck, and the issue became whether or not there was a valid claim against the U.S. Postal Service as a result of a claim filed against the employee. Again, not a case that is on point with any issue that's been raised in this case. And finally, Hagens versus Levine. It was a case in which a New York, state of New York regulation addressed New York's ability to recoup some payments from AFDC, I believe. That violated the Equal Protection Clause of the 14th Amendment. The court did find that the district court did have jurisdiction to hear the plaintiff's claim. Again, I did not find any verbiage from any of these three cases that would raise any type of argument in this case that this court does not have jurisdiction to hear this case.
Thank you, Mr. Brooks. Your response.
Yeah, I respectfully object to that. It's clear in both of those cases that ultimately those cases were called correct by the Supreme Court, and that both cases ended up being voided because there was no jurisdiction. Same thing in this case. How it applies is this court has yet to prove that it has jurisdiction. It has not been proven. There's been no certified document paperwork. There's been no proof. There's been no response to the demand for the statement of particulars. There's been no response to we haven't even established that the plaintiff is a living human being and not an entity. There's so many things that have yet to even be proven. And again, if both cases that were just cited were voided by the Supreme Court for lack of jurisdiction, how is this case any different?
Thank you for your arguments, sir. First of all, the Hagens and the Melo decisions, or Melo, these were civil lawsuits. They weren't criminal cases at all. The Lopez decision, while a criminal case, dealt with a federal law and whether the district court had jurisdiction. In Lopez, the U.S. Supreme Court struck down a federal statute that had made an offense criminal, and because of that, there was no jurisdiction. There have been no similar arguments made in this case at all. The arguments that you raise related to the Bill of Particulars, related to those types of issues, have all been debunked throughout the ages in the courts of the United States of America. This court will deny your request to dismiss, deny your request for the demand for particulars, even going back to one of the filings from the 3rd dealing with your demand for a verified statement, your notice of special appearance. All of those things have been noted on the record, but to the extent that the court needs to respond to any of those, once again, your demands and requests and objections are either overruled or denied, as the case may be.
Your Honor, may I respectfully request a legal reconsideration for your ruling?
No, I just went through my reasoning, sir. So without you meeting the standard under a motion for reconsideration under Section 806.07, that request is summarily denied without any further argument. All right, with that...
For the record, may I request a legal or factual basis for your ruling, as you just cited, Your Honor?
I just provided the legal basis, sir.
You just cited a case law from United States versus Veneby, correct?
My reasoning stands. The record before you and on the record speaks for itself. I'm not going to address this any further. Your objections are noted.
Respectfully, Your Honor, may I ask for a written judicial finding of facts and conclusion of law on this matter?
You may request. That request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
That is not an issue this court would address. That would be for an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
That request is denied. This is a court of competent jurisdiction.
Based on what law or fact, Your Honor?
All right, Mr. Brooks, your objections are noted. I want to keep moving forward today.
May I respectfully object to that, Your Honor, based on the fact that you cited something that was a federal law, and then the cases that you went over in the challenge of jurisdiction were all dealing with federal guidelines.
This court's not going to explain the law to you, sir. I've cited the law, but I just direct you to those decisions. I believe they speak for themselves, and your request for any further articulation by this court as to the basis for the court's decision is denied.
May I respectfully object, Your Honor, and and still ask for verified proof of.
Mr. Brooks, I've already addressed that the request is denied. All right, moving on. Can the state? I'm moving on, Mr. Brooks. Thank you. Your objections are noted. Attorney Opper, I'd like to address the issue.
Object, Your Honor.
Your objections noted. I would like to address the issue of the subpoenas that were turned over to the state. If you could just make a record on that.
Yes, thank you. We have received the subpoenas that were provided by Mr. Brooks. I believe there were 12 in total. We are endeavoring to have all the individuals properly served, and we will assist in arranging their appearance here in the courtroom at the appropriate time, with the exception of that one individual who we believe has relocated to the state of Texas. There are no other concerns that the state has at this point in getting those subpoenas served and getting these people here. I do want to advise the court that one of the witnesses on Mr. Brooks' subpoena list does need a Spanish interpreter. And that also reminds me to update the court on our progress in that regard.
There's a possibility that they will need an interpreter. If that's the situation, then I'm going to require that Mr. Marquez be produced at that point for questioning. You'll be questioning him first, since it would be your witness, but I want to make wise use of our resources. Mr. Brooks, any questions about what I've advised you about the interpreter?
I want to state for the record that I object to being called that name. I'm a living and breathing human being.
Did you hear me advise you about the interpreter and making arrangements and potentially calling your witness out of order because of that?
So that should be the first witness called?
It would be out of order. It would still be during the state's case in chief, but if we have the interpreter here because they need it, because they're not clear yet if they need that interpreter or not. If they don't call the interpreter and the interpreter's not here and we haven't made arrangements, then I'm going to work with my staff and the clerk's office to make sure we have an interpreter during your case. You'll just need to tell me where in the 12 you want to call that person so I can better schedule.
In the 13.
Well, you have 13, but one's an out of state, so I'm told. But all right, very good. All right, anything else from the state then?
No, that was it for today, Your Honor.
All right, Mr. Brooks, anything other than what we've already talked about?
Yeah, I don't know if the clerk received 2 ICF forms that I submitted.
I don't know if anything. I can check my electronic inbox. Let me just do that real quick and see if there's anything there.
Well, one of the ICFs we just addressed, that would be the one that I filled out last night, coming back from the proceedings yesterday. We just addressed that. That was dealing with the subpoenas.
Okay. All right. I don't see it. I'll make sure that my staff knows to look for it, and when we get it, it'll be uploaded, and then we can address it at a break.
The other one was dealing with asking for my court docket sheet.
What do you mean by that, sir?
I would like a certified copy of my court docket sheet.
I need to know what you mean by that, sir. There's many documents in the record. There are docket entries that are part of the electronic file.
Is the entire every court proceeding, is that part of the electronic file? What did you just say?
You mean a recording of the proceedings?
No.
Record?
I want the actual docket sheet from every court proceeding that I've had in dealing with this matter.
Well, you'll have to address that to the clerk of court.
I did.
Okay, so then that's why it didn't come to me and I wouldn't seen it. I'm not the custodian of the record. It's the clerk of court under the statute. So
was it received?
I don't know, but I can find out. And on a break we can advise. I'll direct Teresa to find out from the clerk of court if she received that.
How old is Adelia?
She's 10 now. She was 9 at the time.
Okay. She was walking with you with Burris Logistics?
Yes. As I turned, all I seen was the hood of a red vehicle, and I hit the red vehicle and rolled down to the side and landed directly between the Burris Logistics float and the red vehicle, and I seen the tire go directly in front of my face.
Okay.
After I realized what just happened, I jumped up and took off running to go find her, and I seen her in the middle of the road, which I don't know how she got to that position from where I seen her last.
We are going to play with audio at normal speed from the beginning until about the 26-second mark. And let's go at about 50% speed.
Objection was the relevance of showing the video to us.
Overruled.
Grounds.
It's relevant.
Grounds.
And we'll play from the beginning. What did we see you doing at the end of the video there?
I was laying between the vehicles.
Did you get up at some point?
Yes,
Okay, and then
ran directly to my daughter.
The vehicle that struck you, do you recall seeing a driver?
No, I seen the red hood of the vehicle. That's
So
all
you-
I seen.
So you didn't see the driver or anybody in the vehicle?
No, again, I just seen the red hood as it ran into me.
No license plates or?
Nope.
You recall how fast the vehicle might have been traveling when you were struck?
It had to have been going at decent speed. As I said before, I did see the rear tire going past my face, and it all happened extremely fast.
So you don't recall?
With the chaos that was going around that day, no, I do not remember exactly.
And you stated that after you were struck, you got up and ran to your daughter, correct?
Yes,
And you were able to do that with your leg injury?
yes. I guess that would be the adrenaline going through your body at that moment in time. It did give me the strength to run to my daughter.
So when was it that you knew that you had the, I think you said knee injury?
Yes, knee and hand.
When did that pain in your leg set in?
It was immediately.
But you were still able to get up and run.
Yeah.
Were you able to see what the vehicle did after you were struck?
No, my only attention at that point in time was to find my daughter and attend to my daughter.
So you didn't see what, the route that the vehicle traveled or anything after that?
I seen the aftermath after it went through. That was it.
Do you recall any reports coming over any radios by law enforcement?
I do not recall that. The only thing I heard after we were hit was shots fired.
So you did hear shots fired. Did that
I
come
don't
from?
know if it was directly from a cop or if it was people running.
Did you hear the shots?
I did not.
So after you were struck, it would be fair to say that it got louder than what it was before.
After, in the middle of the complete chaos, yes.
With all the noise and chaos going on, do you think it would have been hard for you to hear a horn honking?
I did not hear a horn.
Would it have been hard? The question was, would it have been hard for you to hear it?
Before it got to us or after?
After it became chaotic.
I was not listening for a horn after we had already been hit by the vehicle.
So it'd be fair to say you wouldn't be able to recall.
I would not be able to recall that.
Did you file any claim in this incident?
What do you mean by claim?
Did you file a report as an injured party in this matter?
Yes.
So it would be fair to say that you identify yourself as an injured party?
I was injured by the circumstances that day, yes.
Have you seen or read a complaint in this matter?
What do you mean by that?
Have you seen a written complaint or read a written complaint in this matter?
Objection.
Grounds.
Mr. Brooks, are you referring to the criminal complaint in this case or something else?
I'm referring to something else, the complaint.
Well, then I'll sustain the objection as to the form of the question. It's vague.
May I respectfully ask on what grounds, Your Honor?
It's vague. Next question, or rephrase.
Do you know of any complaint being filed in this matter?
Objection.
Grounds.
Sustained.
Grounds.
As to the form of the question.
Were you aware that it may be possible that you could give testimony in this matter?
Yes, I was aware of that.
Did you seek to give testimony in this matter?
I was okay with doing so.
And who were you informed by?
The district attorney's office.
Was that in form of a subpoena, or was it a conversation?
Well, at first it was knowing that there was a possibility, and then the subpoena.
So it'd be fair to say that you did have a conversation
Conversation?
with the district attorney's office.
Yes.
Did they ever inform you of who the plaintiff was in this matter?
Objection. Relevance.
Grounds.
Sustained.
Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Relevance.
Grounds.
Sustained.
Have you ever talked to the plaintiff in this matter? Ever seen the plaintiff in this matter?
Objection. Relevance.
Grounds.
Sustained under 90611. Mr. Brooks, you need to move on to a new topic or I will close the cross-exam.
I will move on. It has to be some type of ground stated other than relevancy or anything like that. The real ground should be put on record, Your Honor. We all deserve to know. The jury deserves to know.
It's not relevant. Move on.
So are you bringing this claim against the accused defendant in this matter?
Objection. Vague.
Grounds.
Sustained.
On what grounds, Your Honor?
It's vague. As to the form of the question.
Have you seek to receive any recovered damages or anything in the matter?
The only thing that we got was help to pay for our medical bills, as that was something that was completely unexpected from a Christmas parade.
Is that through the state of Wisconsin?
It was through, I forgot the name of what it was.
Are you listed as a plaintiff in this matter?
Am I listed as a plaintiff in this
Are
matter?
you the plaintiff? Did you file the claim?
Objection.
That's a compound
Relevance.
question. Sustained as to the form of the question. Mr. Brooks?
Did you
under
file a claim?
90611. Move on. You've already asked about whether she filed a report. Move on.
Do you see the state of Wisconsin present in the court?
Objection.
Grounds.
Sustained under 90611. I warned you to avoid that topic or I would cease cross-exam, so I'll give you one more opportunity to ask a different line of questioning.
Do you recall when you gave your interview to law enforcement?
It was a few days after.
Would it be fair to say it was a few days or a week or so?
I don't actually remember the exact time.
Do you recall if it was on November 30 of 2021?
I don't remember the exact date.
Can you recall why it took a little bit for you to be interviewed by law enforcement?
I'm guessing because of how many people were injured throughout this parade. It did take a while to get around to everybody.
Did you seek to be interviewed in any way?
I don't think I seeked, but I did inform them that I was injured, as well as my daughter.
But you don't recall calling any law enforcement or attempting to file a report?
Law enforcement that was there at the parade took people's name, and it all ended up going to them.
Do you recall stating that you did not see what happened to your daughter?
I do recall that. I still to this day don't know directly what happened to my daughter. I just know that she was hit by the red vehicle as I was laying on the ground after I was hit.
So it would be fair to say if you didn't see what actually happened to your daughter, you didn't see what happened to anyone else?
Objection.
Grounds.
Characterization of the
Grounds.
events.
Sustained as to the form of the question.
Would it be fair to say that it was difficult to see if anyone else was struck?
From the position I was in, I seen a tire going in front of me, so no, I did not see directly anywhere besides the tire going in front of my face.
So it would be fair to say that you didn't see anyone get struck besides yourself?
It would be kind of difficult to see beyond that.
Can I just clarify, Ms. Grabo? The last time you saw your daughter before you got struck, where was she?
Objection. Irrelevant.
Overruled.
She was walking over, or she came over by me to get more candy to pass out, and she was walking off to the sidewalk to hand out more candy.
Sidewalk on which side of the Burris float?
Objection. Hearsay.
Overruled.
That would be to the driver's side so to the left.
Okay. And then you got struck. And where's the next place that you saw Adelia?
I seen Adelia.
Overruled.
She didn't see anything.
It's not hearsay, Mr. Brooks.
That's the definition of hearsay.
Mr. Brooks, the objection is noted. It's overruled.
On what grounds, Your Honor?
I direct your attention to section 90801, sir. You may answer the question.
After I got up, I found my daughter in the middle of the road. She was no longer by the sidewalk.
Where was she in relation to the Burris, the truck that was pulling the float?
Objection. Hearsay.
Overruled.
On what grounds?
Direct your attention to 90801, sir. It's not hearsay. Go ahead, you may answer.
She was towards the driver's side, the front end of the vehicle. So she was more towards the front of the vehicle.
You testified that after you were struck, the noise in the area increased. It got louder. You
Yes.
saying that? And so, as a result of that increase in noise, you weren't listening for a horn?
No,
Okay. What about before you got struck? Did you hear the sound of a horn?
I did not.
Hearsay.
It's not hearsay. Overruled. Would you just repeat your answer, please?
I did not hear a horn.
Thank you.
Are you familiar with the program, the Waukesha Blazers Youth Baseball Program?
Yes,
Overruled.
Yes, I currently serve as the president.
Are you also a coach with the Blazers?
I am.
Okay. So direct your attention to November 21st of last year. Were the Blazers part of the City of Waukesha Christmas Parade?
Yes, we were.
Were two of your kids there, Caden, Cayden, and Riley, Ryle?
Yes.
And which one of those, does either one of those play with the program?
Kaden plays on my team.
Okay, and Riley was there for,
Support.
Okay.
She used to play in the program.
okay, and then you had a third child there.
Yes.
Was there a group immediately after the Blazers team in the parade?
Objection. Relevant.
Overruled.
Did you hear any type of commotion or anything that drew your attention to behind you during the parade route?
Yes, I remember hearing some sort of scream. Couldn't tell if it was part of the parade or not. Turned over my left shoulder and I saw people running, or heard people running and lots of screaming. So I turned around again, and that's when I saw a red SUV coming at us, and I pulled my daughter Maya out of the way.
Maya was next to you?
Yes.
And if you can recall, was the vehicle in the middle of Main Street?
Objection. Hearsay.
Overruled. You may answer, sir.
From what I remember, yes.
It sounds like you were behind the truck. You said Caden was to your left, which would be, and I'm horrible at directions, but that would be the south side of the street. Was it coming on the south side of the street, the middle of the street, or the north side of the street, which would have been to your right?
Objection. Hearsay.
Overruled. You may answer.
From what I remember, it was middle, and then it moved to the left to go around our truck. I was frantically looking for my kids. I watched the SUV continue driving down the parade route, swerved back to the right after it passed our truck. I was screaming, "Where's Riley?" I ran around the truck a couple times, and that's when I saw Jackson on the ground and stopped by him.
What observations did you make of Jackson?
Jackson was motionless on the ground, eyes open, didn't appear to be aware.
Did you find out that he died as a result of being struck?
I did.
Hearsay.
Overruled. This answer may stand.
Do you know if Caden got struck by the red SUV?
Objection. Hearsay.
Overruled.
Yes, he did.
Did you see Jackson or Tucker Sparks get struck by the SUV?
Sitting here today, I do not remember that.
Okay. Did you give a statement sent out by the victim witness program, and then you would have sent it back? Do you recall that?
Yes, I do.
And was that something that you created?
Yes, those are my words.
Okay. And is it correct that that form says, after that I saw the car drive past us on the left, striking two of our players, Tucker and Jackson Sparks?
Yes.
Objection. Hearsay.
Overruled.
See that? That's hearsay.
Overruled. His answer may stand.
Thank you. I'm assuming that the event was fresher in your mind when you gave that statement versus a year later?
Yes, I believe everything in that statement is accurate.
Okay, thank you. And do you know if Jackson Sparks was injured? I'm sorry, Tucker Sparks.
Yes, he was.
Okay. Do you know what injuries he had?
Objection. Hearsay.
Overruled.
I remember the most significant was brain bleed or a head injury.
Now, after the car went to the left side of the Blazers truck, striking the kids, did you see the path that it took?
Objection. Hearsay.
Overruled.
Yes, I remember it going back to the right side of the road after that.
So after it passed the truck,
Yes.
do you know approximately how far Jackson was in front of the Blazers truck when you went and you talked to his father, Aaron, who was with Jackson?
Objection. Hearsay.
Overruled.
I don't remember.
Okay. Can you estimate approximately how fast it was going before when you first took notice of the red SUV when you looked back?
Objection. Hearsay.
Overruled.
I remember thinking, this is a parade. It's 25-mile-an-hour speed limit here. If I were in my neighborhood and a car was going that fast, I would be yelling at it. So faster than the speed limit.
And I'm assuming when you're in a parade, you're not going, although the speed limit on that road might be 25 miles per hour, you're not going 25 miles per hour. Would that be a correct statement?
Absolutely.
Objection. Hearsay.
Overruled. His answer may stand.
So, did you see Jackson a second time on Main Street?
Yeah.
Objection. Hearsay.
Overruled.
Probably more on the upper part. It has names: Josh Craner, Riley Rogers, Caden Rogers, Jackson Sparks, and Tucker Sparks. There's a line on the left side of that diagram that goes down to the map where it leads to a yellow star. Do you see that?
Yes.
Would that be the area in which each of those people were struck by the red SUV?
Objection. Hearsay.
Overruled.
Yes, it appears accurate.
I'm now going to show you what's been marked as Exhibit 148. I'm going to have it just shown in front of you first. Have you seen this video before?
I have.
And does it accurately depict what occurred on November 21st of last year, shortly before, during, and after the red SUV struck the Blazers?
Yes.
Okay. Permission to publish and admit Exhibit 148 into evidence.
Objection is noted. Exhibit 148 is received. Permission to publish is granted.
On what grounds?
Sir, it's approximately 3 minutes and 22 seconds. I'm going to play that entire video.
What is the relevance of showing the entire video?
Your objection is noted. It's overruled.
What grounds?
Relevance.
What grounds?
That is the grounds. Relevance. Go ahead.
And finally, I'm going to show you Exhibit 31. I'm not going to have it published until I show you a couple seconds of this to see if you can indicate that this is a true representation of what happened on November 21st.
I see it, and it is.
Okay.
Exhibit 31 is received. Permission to publish is granted.
And if we can play it. And it was played until the end at 27 seconds. Does that accurately depict the path of the vehicle as it was striking the Blazers members?
Yes.
Nothing further, thank you.
All right, I'm going to take a mid-morning break at this point, about 15 to 20 minutes. All rise for the jury, please. We will go back on their record appearances are as they were before. I will have the jury brought out and we'll continue with the questioning of this witness.
Judicial determination you made about the jurisdiction?
I thought I was very clear, sir.
So will proof be validated?
Your request is denied.
On what legal basis, Your Honor?
The record stands, sir.
Is that a judicial determination?
My ruling was put on the record earlier, sir.
So that is a judicial determination?
Mr. Brooks, you may start your questioning of this witness then.
Just a second, I'm sorry about that, I just needed a second. I apologize to the witnesses. A little emotional right now for me, so I apologize to the court as well for the delay. Can you recall what time you arrived at the parade that evening?
I don't remember exactly.
Do you recall how long you intended to stay?
Through the parade till it was done.
stated in testimony earlier that you did not see the vehicle strike the children that were in front of you. Would that be fair to say?
I said sitting here today, I don't remember that.
You said something to that effect. Would that be fair to say?
You'd have to be more clear.
You said something to that effect of what you just said.
To what effect?
That you, sitting here today, that you do not recall seeing anyone struck ahead of you.
That's correct.
But then you also stated that you did see who was struck ahead of you.
Is that a question?
Would that be fair to say?
In relation to what?
In relation to someone being struck in front of you
When I was there or the video? What are you talking about?
at any time when you was there.
When I wrote my statement, I wrote what I remembered at that time.
So would it be fair to say that as you sit here today that anything about your statement may have changed?
Nothing has changed.
So your testimony here today would be accurate to what you reported?
Everything I said has been accurate.
Do you recall saying in your interview with the DIC that your 11-year-old son and 9-year-old daughter suffered minor injuries in the event?
I remember saying they were injured.
Do you recall saying that the injuries were minor?
No.
Now, direct the witness to the statement.
Do you have a copy of that?
Yes, right here.
Is it his statement or a summary?
It's not his statement, it is a statement from DCI, an agent from DCI, in which the DCI agent spoke with Mr. Rogers and wrote down what he believed was said to him. It was not signed by Mr. Rogers, it was not reviewed by Mr. Rogers, therefore I would object to this being characterized as this witness's statement.
Grounds.
If he would like to call the DCI agent, then he may do so.
Grounds.
Right, I'm going to sustain the objection as to the form of the question. Rephrase, if you're able or desire.
Do you recall stating to whomever interviewed you from the DCI that the injuries were minor?
No.
Any reason why they would report that you said that?
I don't know. You'd have to ask them.
Any reason why they would believe that that's what you said?
Objection.
Reported. Grounds.
Relevance.
Grounds.
Calls for speculation on the part of the witness. Sustained.
Do you remember giving a prepared statement at 10:45 a.m. on 11/22 of 2021?
I do.
Do you recall the gist of what you prepared?
Can you be more specific?
Specifically, that you heard commotion, turned around to see a stroller or something fall over about a block and a half behind us.
Yes,
You recall making that statement?
I do.
About how many people would you estimate was at the parade that day?
I would guess the thousands.
And you were able to see something fall over from a block and a half away amidst thousands of people?
Yes.
And you don't recall what that was that you saw?
No.
Any reason as to why you would name what you saw fall if you don't recall it?
I described it.
So you did see something fall.
Objection asked and answered.
Grounds.
Asked and answered. Sustained.
Do you recall what the item was?
Objection.
Grounds.
Asked and answered.
Grounds.
Sustained.
Do you recall about what time you heard that shots were fired?
After watching the video, it's about 3 minutes, 2-3 minutes after the red SUV drove by us.
Do you recall the day of the incident? Not the video.
I remember it was after the vehicle drove by us.
What did you do after you heard that shots were fired?
I looked for all of my children again and made the decision to take 2 of them into the antique store.
About how long did it take you to look for everybody before you went into the antique store?
Before or after the shots fired comment?
After the shots fired, comment.
I think I did another lap around the car and then around our Blazers truck and then grabbed my kids and left.
Were you able to retrieve everyone at that time?
No.
You recall who was missing?
Riley was missing.
Did you leave the antique shop anytime after you had gathered your loved ones into the antique shop?
Yes.
Do you remember what you did when you left the antique shop?
I remember at some point seeing Jackson again on the ground.
Did you continue looking for the loved one that you missed before you gathered the other ones into the antique shop?
To the best of my recollection.
You don't recall for sure?
It was pretty chaotic. I was looking constantly for my missing daughter.
Were you injured in any way?
No physical injuries.
You had one of your daughters, Maya, with you that day. Would that be fair to say?
That's fair to say.
Was she injured in the event?
I threw her to the ground to get her out of the way, so she had some scrapes.
And would that result from you throwing her to the ground?
I don't know.
Do you recall if anyone else besides your children who were injured?
I remember lots of people who were injured.
Do you recall
I just answered that.
specifically? Do you remember who besides your children?
You want me to list all of the names that were injured?
Just rough estimate. That you recall.
That I recall, 10 to 15 people that I saw.
That you actually observed.
Yes.
Did you render any assistance to any of those people?
No.
Any reason why not?
My daughter was missing.
So it'd be fair to say at that moment your concern was your daughter that you didn't retrieve to go into the antique shop.
My concern was for everyone that was just struck by the vehicle.
Including your daughter that was missing, right?
I was concerned about her missing, yes.
Did you file any reports other than just interview?
What do you mean by
Like an
reports?
injury report of any kind?
Just what you had in front of you that you were reading from. That was my statement.
No. Did you file any injury reports or
Objection, that's a big question.
grounds?
Sustained as to the form of the question, sir. Please rephrase.
What I'm asking is, usually if there's an injury, you will file a complaint. To the best of your recollection, did you file any complaint from the incident?
I wouldn't consider it a complaint. I filed some paperwork saying that my children were injured, yes.
Do you recall if that was a complaint?
I don't know.
Was it a claim in any sort of way?
Yes.
Do you recall what the claim was?
It was with the Victim Assistance Program.
And what does that consist of? What are their resources in pursuant to the complaint that you filed? Or claim that you filed, right?
It was to help with any medical bills that arose out of this situation.
So it would be fair to say that you had a financial interest in this incident.
This
Grounds.
characterizes the testimony.
Grounds. I believe it's relevant to the fact that bills were needed to be paid. It's relevant.
Overruled, he may answer.
I was looking to get the medical bills covered, yes.
So would that be fair to say that you had a financial interest?
I would say sitting here today, I didn't care if it got approved or not. I was trying to get assistance for the medical bills.
So if it hadn't gotten approved, would you have been able to do it yourself, or would you have seek to do it yourself?
Objections to relevance.
Grounds.
Sustained, the question is vague.
Would you have seeking? Would you have paid the medical bills yourself,
Yes,
regardless to price?
I generally pay my bills.
In specifically that matter, not the rest of your bills. Specifically that matter.
Objections to relevance.
Grounds.
Sustained. Move on, Mr. Brooks.
Would you consider yourself an injured party in this case?
No,
Were you aware that you might be called to testify in this case?
eventually, yes.
Did you seek to testify in this case?
No,
May I ask why you agreed to testify if you didn't seek to?
Objections to relevance.
Grounds.
Sustained.
Do you recall who informed you via subpoena to testify?
I received a subpoena from the DA's office, yes.
You did?
Yes,
Sorry, I didn't hear that. Are you aware of the plaintiff in this case?
Objection to relevance.
Grounds.
Sustained.
Have you read a complaint pursuant to this case at any time?
not that I remember, no.
Do you understand that for charges to be issued that it has to be a claim, therefore it has to be a plaintiff?
Objection.
Grounds.
Okay, so first of all, the
Grounds.
grounds are relevancy. It's not relevant. That would be the
You
grounds.
also have to state the grounds.
Hold on. Let her get her position out, Mr. Brooks.
And it mischaracterizes the former testimony.
It does
Sustained
not.
as to both grounds. Under 90611, move on, please.
So you're not sure if there's a plaintiff?
Objection.
Grounds.
Relevance.
Sustained.
Have you ever had any interaction with the plaintiff?
Objection.
Grounds.
Sustained.
Are you aware who brought charges in this matter?
Objection.
Grounds.
Sustained.
If you're not sure of a complaint, how can you be sure of the charges in this case?
Objection.
Grounds.
Sustained. Mr. Brooks, under 90611, please move on to a new topic, or your cross-examination will be shortened and cut off.
Your Honor, with all due respect, every question that I'm asking is relevant. It pertains to the plaintiff in this matter that seems to be nowhere
Mr. Brooks, you're
found.
making a legal argument. We'll take that up outside the presence of the jury. Move on.
I believe the jury deserves to know who the plaintiff is in this matter. That's very relevant to the case. How can they rule on something when they don't
Mr.
even know
Brooks,
who the plaintiff is?
Please, move on. Next question, or I will turn it back over to the state for redirect.
Were you able to catch a glimpse of the license plates?
No,
Do you recall if the vehicle had any tinted windows?
I don't remember.
About how far from the vehicle were you when it passed you?
From the red SUV?
About how far from the vehicle were you when it passed you?
Can you tell me which vehicle you're talking about?
How far from the vehicle were you when it passed you? The vehicle that went around your Blazers vehicle.
The
Your Honor,
red-
I guess I would ask the defendant to be more clear as to what vehicle and when it went around, like at the beginning of the parade, before it struck his kids.
I was just clear. I said the vehicle that went around his Blazers
Sustained
vehicle.
as to the form of the question. Please rephrase.
The vehicle that you observed, well, rather I'll say the vehicle that you observed approaching. About how far from it were you when it passed you?
Objection, just to clarify, is he saying the red SUV that this witness has described as that red SUV was approaching him, or some other vehicle?
Sustained as to the form of the question.
Well, I thought he was clear when he said that there
You
was
have to
only
be clear
one
with your question,
vehicle.
Mr. Brooks.
Excuse me, Your Honor?
You have to be clear with your question. It's
Well,
vague.
he
As
said
to
it
the
was only
word
one.
vehicle, you need to be clear which vehicle you're questioning the witness
The
about.
vehicle that was approaching, that he said
At
was
what point
approaching.
in time, what color is the vehicle, something like that, sir.
The vehicle that you observed strike anyone. How close were you to that vehicle when it passed you?
The red SUV was about 10 feet probably from me.
And you didn't see the driver, correct?
Correct.
Did you see anyone else in the vehicle?
I did not look in the vehicle.
Would it be fair to say that 10 feet from a vehicle is pretty close?
Subjective.
What would you say? Would you say that's pretty close?
It depends what you're talking about.
Would you say that 10 feet is pretty close to a vehicle?
Depends. If they're driving, yes.
Would it be fair to say that that's close enough to be able to see who is driving?
It depends on many other factors.
What would those factors be?
Eyesight, windows up, down. If they're looking at the vehicle,
I'm assuming it would be fair to say that you were definitely looking at the vehicle, correct? Would that be fair to say?
when?
When it was approaching and when it passed?
Yes.
Any reason why you would not try to identify the driver?
Because my children were about to be struck.
Any reason why you would not try to see if you can catch a license plate number?
Because people had just been hit.
So it would be fair to say because of what you was observing, that would be the reason why you didn't try to get a description of the driver or the license plate.
My priority at the time was not identifying the driver.
Sir, you had indicated that you submitted a claim to the victim witness program for medical bills. Is that correct?
Correct.
Were those the medical bills for Caden and Riley that were incurred as a result of the red SUV hitting both of those children?
Yes.
Objection, relevant.
Overruled. His answer may stand.
And it was yes?
Reminder
Yes.
to wait till I.
Sure.
No
Thank you.
problem.
No further questions, thank you. Were you there with your son or daughter?
My son and my wife.
Okay. And you were marching with the Blazers.
Yes.
Did there come a time when you heard a commotion behind the truck?
Yes.
Can you describe for the jury what exactly you heard?
I heard screaming.
Now, you were at a parade, so I'm assuming as part of a parade there's normally screaming. Was it something different?
Yes.
Can you describe it?
Horrific.
What did you see?
I saw a red Ford Escape up on the curb. I saw people throwing themselves out of the way.
You saw people running from the area that the car was coming from?
Yes.
Then what happened?
I was struck by the vehicle.
Did you receive injuries as a result of the vehicle striking you?
Yes.
And what were those injuries?
I couldn't walk. I was in the hospital. I had muscle contusions. I had bone bruises.
Did the vehicle, when it struck you, or after it struck you, did the vehicle continue on with its path of travel down the parade route?
Yes.
Overruled.
Could you tell if it went straight ahead, swerved one way or the other way?
No.
Overruled. He may answer.
No.
I'm going to show you what's been previously received as State's Exhibit 11. Do you see yourself in this still shot?
Yes.
Can you circle where you are? I'm going to show you Exhibit 148, and I'm just going to play it through the first time. What did you see in that video, sir?
Being struck.
Playing it, it looks like you're running towards something, and let me play it and then pause it when I see that beginning. Do you recall what you were running towards?
My son.
Okay. And that would have been where he was at that time of the parade?
Yes, on the left side.
All right, you may take the video down, please. All right, go ahead.
I might need that same video.
All right, well, let me know when you need it. Go ahead, you may start your cross.
Can you pull that exhibit up again, 148? Can you pause it right there? Can you identify for the jury where you are in this video if you see yourself? You can unpause it. All right. Have you seen this video before today?
Just still shots of it, not the video itself.
So it'd be fair to say that this is only your second time seeing this video.
Yes.
Do you, you could take the video down, I'm sorry. Do you recall saying that you needed a walker to assist you in moving?
Yes.
Would it be fair to say that you're moving pretty good these days?
Objections or relevance?
Grounds.
Sustained.
Would it be fair to say that you're walking pretty good as of now?
Objection.
Grounds. Just walk to the
Sustained.
bench.
Not relevant.
Did you also remember stating that you don't remember much from the event?
I do not remember saying that.
Do you recall what you did after being struck?
I could not move. I was on the ground.
Do you recall how long before you were moved from your position?
Couple minutes.
Were you helped by someone, or?
Yes, 2 people.
And where did they take you?
Into the joke shop.
And from there, did you receive any medical attention?
Yes.
Do you recall where that was?
Memorial Hospital.
You recall who took you to Memorial Hospital?
A squad car.
You remember the officer's name?
No.
Do you recall what date you made the report to the officer? Or the date that you were interviewed, rather?
Which time?
So there was more than one time?
Yes.
After being struck, you testified that you saw the vehicle kind of go up on the curb. Would that be fair to say?
Can you ask that again?
What did you see the vehicle do after it struck you?
After it struck me, it continued.
What did you see it do?
Drove off.
Did you see it strike anyone at that point?
No.
Were you able to get a look at the driver in any way?
No.
A license plate number in any way?
No.
You testified for the jury earlier that you heard screams from behind you before you were struck. Did you see the vehicle approaching at that point? Did you turn to see if anything was approaching at that point, rather?
Yes.
About how far was the vehicle away from you at that time that you observed it?
20 yards.
You were able to make that assumption how?
I'm a coach and we go off yardage a lot.
That makes sense. Would it be fair to say that that's relatively close?
Yes.
Close enough for you to see into the vehicle?
I did not see into the vehicle.
And just so I'm correct for the record, you said that you said that your children were not injured in the incident. Would that be fair to say?
Not physically.
Grounds?
The witness answered it. His answer may stand, so the objection is overruled.
And when you were treated at Memorial Hospital, did you receive any pain medications, Tylenol, ibuprofen, anything like that?
Yes.
In the days after the event, did you file any claim whatsoever?
Can you be more descriptive?
Did you file a claim as an injured party?
Yes.
Do you remember who that was with?
No.
So would you consider yourself to be an injured party in this matter?
Absolutely.
So you would consider yourself to be a plaintiff?
Objection.
Grounds?
Sustained on relevance grounds.
Do you recall who called you to testify in this matter?
The DA?
Can you point out for the jury which DA?
No.
Do you see him in court?
No.
Do you recall the name of the DA that you were referring to?
I got
Objection to relevance for this
Grounds?
hearing.
Sustained. He's already indicated that the district attorney's office issued the subpoena.
Well, actually, he said the DA, so that was pretty vague.
Sir, did you mean the district attorney's office?
Yes.
Next question, please.
Were you subpoenaed?
Yes.
Do you recall the name on the subpoena?
Objection.
Grounds?
Sustained.
So to the best of your knowledge, you're not aware of any plaintiff in this matter?
Objection to
Grounds?
relevance.
Sustained.
To the best of your knowledge, you have never seen the plaintiff in this matter?
Objection to
Grounds?
relevance.
Sustained.
Have you ever seen or read a complaint in this matter of any kind?
Yes.
Would you state what that was for the record and for the jury?
I just saw the stuff in the news.
And seeing stuff on the news would amount to a complaint?
Sorry, I misheard your question. Can you ask it again?
Have you read or seen a complaint in this matter?
No.
But it would be fair to say, just based on your testimony, that you saw reporting on the incident in the news. Would that be fair to say?
Yes.
Do you recall what you saw in the news?
Just information about the trial.
Would it be fair to say that this matter has been going on for quite some time, that there were a lot of reports in the news? Would that be fair to say?
Objection to relevance.
Grounds?
Ms. Brooks, unless you can tie it into relevance with this witness, I'm inclined to sustain that objection.
I'm going somewhere with it.
Then just ask the question, sir.
Have you yourself seen anything in the news before the scheduled trial in regards to this matter?
Yes.
Can you state for the record and for the jury what that was?
Just information about the trial itself.
Did you at any time see any reports about the alleged defendant at any time?
Mr. Brooks, I'm gonna, under 906.11, this is not a witness who identified the driver, so I'm not sure where the relevance is of this. We'll take it up outside the presence of the jury.
You testified a few minutes earlier that you really don't remember much after being struck. Do you recall where you were after being struck?
I was on the ground.
I'm just gonna excuse the jury momentarily. We'll let you know when you can be brought back in. All rise for the jury, please. All right, thank you. Be seated. Mr. Brooks, I cut you off when you were asking questions about what this witness had seen on the news. I'll give you an opportunity to give me an offer of proof as to why you believe that's relevant and specifically as to this witness.
Well, it's relevant because of how close he testified to being away from the vehicle. He testified to being 20 yards away from the vehicle, which is not super close, but it's not far enough that you wouldn't be able to see a driver or see into the car.
Well, so that's an argument, sir. So what questions would you have that you didn't already ask, and how does the news reports relate to that?
Maybe he may have seen the alleged defendant on the news, and maybe that may jog his memory back to if he seen the driver.
But he testified he didn't see the driver. So
he also testified to never making the comment that he didn't remember the event, but it's clearly in his summary and in his report that he said that. So it's conflicting. His report is conflicting with what he's testifying. So I was trying to get at the credibility of it. That was my whole aim.
What does the news reports have to do with that, sir?
The news reports are relevant just by the sheer amount of reporting that they've been reported. This has been going on for a year.
The news reports don't have any bearing on his credibility. The points that you bring up are arguments that you may make if you choose during your closing arguments. But the questions you were asking don't further that theory. So that's why I cut you off, because there was not anything that you were connecting by way of relevance.
With all due respect, Your Honor, a lot of the questions I ask are objected to. It seems like I can't even get to the questions that need to be answered.
Sir, many of your questions go to these sovereign ideas that are frivolous arguments about the plaintiff and all of that. We give you a little bit of leeway. I give you a little bit of leeway on it. So ask relevant questions, they'll be answered. So I don't see any need for this witness to be brought back in, so that witness is excused. Who's the next witness?
With all respect, on the record, Your Honor.
I've asked a question of the state. Let them answer, please.
Will I be able
Mr. Brooks, let them answer. Hold on.
So the next witness that we had intended on calling is Detective Mike Carpenter with the Waukesha Police Department, who would provide testimony about his conducting the speed analysis of the vehicle. I don't expect that we'd be able to get through direct. Well, we might be able to get through direct.
I'd like to at least have him start. I want to go closer to the lunch hour today.
So the other issue is that we thought we were going to be breaking for lunch, so he's not in the building right now. We have another witness who is ready, who we could call out of order, but that would be moving into a new topic, a new group along the parade route. So we're fine with whatever the court wants to do.
I'd like to keep going, so I'll defer to you on which witness to call. All right, we'll bring the jury back out, and you may call. Quickly, Mr. Brooks.
You made reference to questions I asked and being, you said something to the effect of sovereign things. I don't understand what you mean by that. I have no anticipation on your rulings. I'm not trying to sit here and I got enough work to do on the fly. I'm definitely not trying to sit here and trying to anticipate what will be objected to, what will be ruled on in any way. I'm merely just, it was understood that this would be a whole new thing for me to do. I apologize if I'm not as polished as I should be working on 3 days time before a trial. We see all the work that I haven't even gone through.
Mr. Brooks, the jury's coming back in.
For the record, I don't consent to that name, and I don't consent to the arguments that the prosecution made. There are relevant questions, as the jury deserves
Mr.
to
Brooks,
know.
please.
The jury deserves to know who the plaintiff is in this matter. I think it's fair to them, if they're to make an informed and intelligent decision, they should know who the plaintiff is.
Sir, your objection's noted for the record.
Can I ask for a legal finding of fact on that ruling, Your Honor? Or is that a judicial determination, Your Honor?
Thank you, everyone. Please be seated.
Was your group, the Extreme Dance Group, marching in the Waukesha Christmas Parade that day?
Yes.
Was there a vehicle or a float associated with your group in the parade?
Yeah, there was a truck.
What kind of truck?
It was.
Pickup truck?
Yes. Yeah. Yeah.
What's the objection? Her answer may stand. I'll instruct the state to avoid leading questions.
About how many times did you make it through your routine during that parade?
Objection, irrelevant.
Overruled.
I don't recall.
Was there a certain point when your dancers stopped dancing?
Objection, irrelevant.
Overruled. You may answer.
Yeah, they did stop dancing.
I would move Exhibit 33 into evidence and ask for permission to publish.
Before I allow that, if you could ask her about the non-labeled boxes.
Sure. You can see that there are some boxes on this diagram that don't have names in them, is that right?
Correct.
What do those boxes represent?
Who wasn't injured?
How is it legal to instruct the prosecution to ask a question that they should already know to ask?
Your objection is noted. It's overruled. Exhibit 33 is received and permission to publish is granted.
So the parade route, if we were moving forward, it would be the bottom of this page, is that right?
Yeah.
We're going to play just a few seconds of this to see if you recognize it. You played 19 seconds. Do you recognize this video?
Not this video.
Okay. Did you recognize the people in front of the truck holding the banner?
Objection. The witness stated she doesn't recognize the video. How is it permitted?
Your objection's noted. It's overruled.
Does this video appear to be an accurate depiction of your group along the parade route during the Waukesha Christmas Parade?
Yeah.
You may answer.
Yes.
I'd move to admit exhibit number 32 and ask for permission to publish.
I'm sorry, Your Honor. Did you sustain that objection?
I didn't rule on it. Which objection?
That I just objected to?
It was overruled.
Are you making that decision now?
There's been a request by the state to receive Exhibit 32, Mr. Brooks.
I objected.
All right, then your objection's noted. It's overruled.
On what grounds, Your Honor?
Exhibit 32 is received. The foundation has been laid, and permission to publish is granted.
On what grounds, Your Honor?
The record speaks for itself.
On what grounds, Your Honor?
You may play.
What did we see at the end of that video?
Um,
You can take some time.
a car going through the parade.
If you were standing in the middle of your group, were you on the left side or the right side?
Objection,
Overruled. She may answer.
Which way are you looking?
If you're walking down the parade route.
I'm looking towards the truck.
Yep.
I would be on the left side.
Does it appear as though that diagram with the names that we looked at, Exhibit 33, does it appear as though that diagram was an accurate depiction of where the named girls were positioned at the time the SUV came into the group?
Yes.
I'm sorry, what's the objection?
Hearsay.
Overruled.
We're just going to play a few seconds to see if you recognize this. Let's do a few more seconds. Do you recognize this video?
Not the video, but
Do you recognize images from the video?
it's
Objection, hearsay.
Overruled.
Okay. Now do you recognize the video?
yeah.
What does it show?
The car going through and someone
Is
flying.
that an accurate depiction of the scene as you saw it that day?
Mm-hmm.
Hearsay. She already stated she didn't recognize the video.
Mischaracterizes her testimony. Your objection's overruled. It is not hearsay. You may answer. And if you did answer, if you could just repeat it.
Could you?
Is that video an accurate depiction of the scene as you saw it unfold that day?
Yes.
Your answer may stand. Thank you.
What was the answer?
Yes.
Move Exhibit 34 into evidence and request permission to publish. There's a figure on the bottom, on the left side of the screen, who appears to be wearing black with long hair. You recognize that person?
Yes.
You can't even see any features
Mr.
in
Brooks,
there.
that's argumentative. Your objection's noted. It's overruled. You may answer.
Hearsay. Objection for
Not
hearsay.
hearsay. You may answer.
Clear hearsay.
You may answer.
Yes.
Exhibit 34A is received.
This is just 8 seconds long, so we'll play the whole thing to see if you recognize it, okay?
Okay.
Do you recognize that video?
Yes.
Move Exhibit 35 into evidence and request permission to publish.
Objection.
Exhibit 35 is received. Permission to publish. Granted, your objection is noted for the record.
Objection still. Is the video, who even took the video? Is it relevant?
Sir, it's not a objection, it's a statement. We can ask questions later.
Not even a witness that took.
Go ahead.
So, Judge, before we begin, I have to step in here and request that Mr. Brooks be instructed to stop making comments under his breath. This witness is very clearly having an emotional and difficult time testifying, and she doesn't need to hear that.
Objection, she can't hear anything I'm saying.
Mr. Brooks, the mics are very good in this courtroom, so please refrain. All right, keep going.
Thank you. So, Ms. Kajewski, I'd like to work our way through this name by name based on your recollection of what you saw during the parade that day. You knew Vivian Darrell before November 21st, right?
Yes.
And do you recall seeing her either while the SUV was driving through or after?
Objection, hearsay.
It's not hearsay. Overruled.
I saw her after, not during, because I was in the front.
Can you describe the circumstances when you saw her after?
Objection, hearsay.
Mr. Brooks, I'm going to direct your attention to review section 908.01. You have a statute book. Please do that. It's not hearsay.
Moving down the list, Sam Coelho. You recognize that name?
Yes.
And you didn't see her in the hospital afterwards?
Not that night, no.
Did you see her in the days following this incident?
Overruled.
Um, yeah, as soon as the day she was able to have a visitor, I was there.
When you say visitor, what do you mean? Where was she?
Overruled.
She was at Children's.
Children's Hospital?
Yeah.
And you know she was injured as a result of what?
Overruled. She may answer as to what her knowledge of the injuries were.
Yeah, she was there because she was struck.
We put Exhibit 33 back up. So, Ms. Kajewski, there's two remaining names there on the diagram, Isabella Bartelt and Maddie Hollingsworth. Did you see either of them as the SUV went through the group?
I did not.
But based on their positioning, they would have been how close to the SUV, in your best estimate?
Just a couple feet.
You're not able to give an accurate estimate about how fast the SUV was traveling at that point, is that right?
I could.
Okay. Well, please, if you think you can, please tell us how fast do you think it was traveling?
Overruled.
I thought around 55.
Many of your hearsay objections, they're not hearsay at all, sir. And I hope you're not just saying them just to interpose an objection.
For the record, Your Honor, how do I know that the prosecution isn't objecting to anything based on the same assumptions?
I don't understand what you're saying.
A lot of
You have that
times,
statute book, so if you'd like to read the hearsay statute, start with 908:01. I realize you are not a lawyer, Mr. Brooks, but you still should have a good faith basis to make the objection and then not argue with me when I rule on the objection. All right? The state will give its one word or statement. If it's self-evident to the court, I don't need the parties to even say much at all. But that's primarily why your objections based on hearsay. There was one I sustained because it was in fact calling for hearsay. But when a witness has knowledge, hold on, when the witness is not asked to say what another person has said, assuming there's no exception that applies or it's just not hearsay under the rule, and they have otherwise personal knowledge about something, they can provide that answer. So I'm hoping that's helpful to you as you formulate your objections. I just ask that when I rule on them, you not interpose the same objection before the witness has answered. When I say it's overruled, the person may answer, your objection stands, it's noted, it doesn't need to be said again.
I'm now informed. I don't understand how someone can testify to things being told in the hospital. They're not a family member, a parent, or anything. So how would they know what injuries someone would have? How would that information be disclosed to someone without being a parent or a direct relative? That would be hearsay.
Sir, again, people can testify based on personal knowledge. What's hearsay is when it comes into court and they say, so-and-so told me. If they're saying, I was told, or, again, I think you're confusing personal knowledge with hearsay. So you can question people on how they knew that information, but you do that at your peril, because if you open the door for them to tell you how they know, then potentially hearsay is going to come in. So with that, I just wanted to give you that information. I can't obviously further explain to you, sir, other than to say ignorance of the law is not something you can use as a valid kind of defense, or you keep saying I don't understand.
I don't.
You did this of your own free will. You waived your right to an attorney, and the ignorance that you claim is not valid at this point, sir. So
I also
with that,
altered that contract, Your Honor. You accepted the contract in the way that I sent it back to you. Now let's
sir,
be
we don't
fair.
have a contract together. The contract
We do
was
not.
being
You're right.
misapplied in this circumstance. All right, we are in recess. I'll see everyone. Let's be back at 1:30. Thank you, everyone.